All right. So I was gonna talk about the next step, which would be after you have decided after you have determined the objectives and you have decided on who the trustee or trustees shall be, and you have determined the amount or the assets that will be put into trust, then you have to create the instrument. And this instrument is called a trust deed or an agreement. It's the document that spells out the terms of the trust and gives legal ownership of the assets to the trustee. And it also identifies the beneficiaries. And this is the most important and is oftentimes the most complex step that you need to take in creating a trust. And if you don't do it properly, you might create something that you didn't intend. So that is why it is important for you to do it the right way so that you don't have something that may be declared to be null and void because it's not a trust. And the next step after creating something, the next step is to move the subject assets to the trustee. If it's money, move it. If it's the real property, you convey it. And once these things are done, you know that the trust has been created. So once a trust is created, the trustee will run the show. And in running the show, the trustee will follow those steps. In exercising their powers, they must ensure that they're acting in accordance with the law. They're acting bearing in mind that they owe a duty of care to the beneficiaries and that they are not going to act in a conflict of interest situation and that they're going to be reporting and they're going to be providing information. So a trust can be varied, changes can be made by a court, and it may also be terminated by a court, or the trust deed or agreement may provide for the termination of the trust. The set law might say, upon this being completed, this trust will terminate. So that will be the way it's gonna go. For example, like I said, if you invest this upon until the children turn 25, these things will be conveyed to them. When the children turn 25, or the first one turns 25, the trust regarding that first one is going to end because that first one will ask for that money or investment because that first child is the beneficiary of that. So that will end. It will continue like that until everything ends. So if the agreement provides a way to end it, then the trustee can terminate the trust when that thing happens. Even if the trustee doesn't terminate it, the trust will die a natural death when that happens. So a trustee can also terminate the trust in accordance with it, but with the law, they may make an application to court for it to be terminated. And a beneficiary may also make the same application. For example, if the beneficiary believes that the trustee is mismanaging the funds, the assets that are subject of the trust, they may make that application and the court is likely going to jump in and say, no, this is not going to continue. We're going to remove you or we're going to terminate this. So that is it. I hope you find you have taken one or two lessons from this. And what I've told you today will not supplant the need for legal advice if you are seeking to create a trust or make a will or take care of minors or disabled family members or even able family members, but you want certain things to be done in certain ways. So always remember that you can talk to a lawyer for guidance. If you wish to talk to us, you can call us. You can contact us. Our website is dukelaw.ca, and our office phone number is there, 780-761-3853. And of course, our email address, office@dukelaw.ca. Thank you very much. I'm going to wait to get some questions from you.
Awesome. Wow. Thank you. That was a lot of information. Thank you so much, Barrister. So everyone in the room, I have asked you to unmute yourself if you want to. I believe, let me see. So if you want to, okay, so here's a question, Barrister. Can you explain what takes priority in a registered estate or in a family trust, e.g., dealing with minors?
Oh, I would like the person to explain.
I can explain.
Okay, good.
Please.
Okay, good. Yes.
All right. Thank you so much, Barrister. A very well articulated, presentation, and thank you so much for the information. Yeah. I think you were answering something related to like to do with minors.
Yes.
Where they are actually the minors are the beneficiaries of a trust deed. And so my question is, like, if, for example, a parent has got a policy where the children are like beneficiaries, like a segregated fund or a policy, for example, and then there is also, obviously, if the parent passes on, they must be a registered estate as well, right? So the question is, would the children benefit more from which takes precedence? Is it benefiting more from the trust itself, or it will be dealt with from the estate?
So if the children are the beneficiaries of the segregated funds, and they are named the beneficiaries, but is to be held in trust for them, then whatever the children are supposed to get from the estate, the children will still get those things from the estate, because when they are named beneficiaries in a sudden investment, that investment doesn't usually pass through the estate, except if the same person had said in the will that, oh, notwithstanding this trust, this is going to pass through my estate. In that case, the same person is contradicting what they had said in the trust deed that they made. So, but if it's clear that this is the beneficiaries are the children, and this person is the trustee for the children, until the children are able to take over that, the children can still get whatever they are supposed to get from the estate, apart from the segregated funds, which will come to them when the time comes for that to devolve to them. Does that answer your question?
Yes, no, but
I am ready if you can tell me the no aspect of it.
Yeah, I think the main thing was just to say, if it is a segregated fund, if it's something the beneficiary is a minor, right? They bypass probate, if I may say.
Yes.
They bypass the probate issues, and the question is now, and they are minors. Obviously, there must be somebody who has to take a trustee who has to look after that. Whether it is a new trustee or is this registered family trust? That's what I'm not very clear with. And then obviously then the parent estate is registered as well. So the question is, through the bypass of probate, what takes precedence? Is it now what was registered in the trust, that obviously the family assets will be dealt with in the trust, but at the same time there is this issue to say the children were actually named beneficiaries in another, in an asset, which is like a policy or investment, which perhaps can also bypass probate. So, or maybe I'm not asking my question clearly, but
Okay, I will try to explain it the way I understand you're asking it. So the investments have the children as the beneficiaries. Then you have the probate, the estate. So with this, we are assuming that there was actually a will, because you only talk about probate when there is a will. So if anything happens and the beneficiaries here, the children, they do not have if there is a trust, a family trust that says, whatever I have in these segregated funds, that will be held in trust for the children. That means that that particular item has been taken care of. That is no longer going through the probate.
okay.
Thank you. So that is not going through the probate, because the trustee has been appointed. We know that particular investment is there. It is for the children, and this is the trustee who will take care of that. So it's not coming through the probate.
Okay.
But if there is no trustee appointed and these children are still minor, and the will does not say, okay, this is going to be held by this for this person for these children, then the segregated funds or anything like that, any investment like that, will fall back into the estate for distribution. It could still be that it's the children that will get it at the end of the day, but it's going to come into the estate instead of moving on its own.
Okay. So which will be an advantage then? Going through the estate or going through the trust?
So it's always better if the value is of significant amount, it's always better to keep it away from the estate, from the probate, if it's of a significant amount.
Okay, thank you.
Yes. So I do have, and thank you so much, Nick, for those questions. I do have a few clients who have decided to make the estate the beneficiary of their policy. So that exposes the policy to creditors, right? And what would you recommend we do for those?
When you make the estate the beneficiary, what happens is that the person passes on the life policy, the value comes into the estate, and then it goes through probate, and you have to pay for the expenses regarding probate and all of that. Probate is tasking, it takes time, and it's really challenging. If you do have the beneficiary named, you're not going through probate. That is completely off the charts in that regard. The person who is named, if the person, except if the person is a minor, in that case, you might need a trustee for that. But if the person is not a minor, that person takes it right away. You don't have to go through the, assuming that life policy is actually the only major asset in that estate. You don't have to go through probate. You just move.
Okay, so then if everyone, I have made you co-host, so you can unmute yourself if you want to ask a question, because I think that you were having difficulty unmuting. So if you do have a question, either type it in the chat or unmute yourself. I trust everyone here. I trust the people I see. You're not going to be making a lot of background noise, because this recording is going to go on YouTube. So, okay, so Barrister, I have two more questions, and then I'll shut up. We've actually gone over 1 hour. That's cool. Okay, when beneficiaries challenge the will,
yes,
I have seen cases where they want to overturn the will completely.
Yes.
So then what can the trustee do in that situation?
So the trustee may make a court application for directions.
Mhm.
But what happens is that most times the beneficiaries will go to court because that's where you challenge the will.
Yeah.
You cannot just challenge the will on your own. You have to go to court and ask the judge to do this and that. And then the trustee will come in to defend the estate. But because the trustee will be one of the defendants.
Yes.
So they will come in to defend their estate, but at the end of the day, the judge will decide on whether or not to uphold the will and do what the testator had requested, or agree with the one of the beneficiaries or whoever that's challenging the will to say, okay, I agree with you. The person who made this will probably didn't have the capacity to make it. There was undue influence, there was this, there was that.
Right. Okay. Wow. Okay. So I know that we can keep Barrister here for another hour, but we're not going to.
Thank you.
Thank you so much, Barrister. It's been extremely valuable, the information you have given to us. I know that once we post this on YouTube, our community is going to benefit immensely from that. So everyone, please, if you don't have a will, go and talk to Barrister Duke Law. Go and talk to Duke Law, Barrister Nduka, and get a will. And if you are not sure what you've done with your assets in terms of trustee appointments, reach out to us, reach out to whoever invited you, talk to your agent and let them fix it. And again, let's coordinate with you and Barrister. So Barrister, we can name you as a trustee, right? Duke Law.
Yes, the only thing is I'm usually reluctant to because it's a lot of work. Creating the document, yes. Doing all the work, yes, but being a trustee, and I'm usually reluctant. I prefer to act as an advisor to a trustee rather than being a trustee myself.
Okay, so we can reach out to you in terms of that conversation. Right?
Yes.
Okay, sounds good. Thank you so very much. Everyone, please help me to say thank you to Barrister. This has been good. And
Barrister.
Thank you.
Thank
for
you so
listening.
much.
Thank you, Barrister. God bless you.
God bless you too.
Awesome. Okay, we're going to stop the recording now. But again, thank you all, everyone. God bless you. I'll stop the recording.
Thank you.